Welcome back to the Constitutional Clarion. In Australia, the Leader of the Opposition, Peter Dutton, has announced that if elected, the Coalition will build 7 nuclear power plants, 2 in Queensland, 2 in New South Wales, and 1 each in Victoria, Western Australia and South Australia. The power stations would be owned and operated by the Commonwealth Government. While most of the debate about this concerns the cost, safety and the viability of the proposal, it also gives rise to some interesting constitutional and legal issues, which is what this video is about. The first issue is what power would the Commonwealth have to legislate about such issues? For historical reasons, there's nothing directly in the Constitution conferring legislative power on the Commonwealth to run a nuclear power station. Obviously, the most far-seeing of the framers of the Constitution in the 1890s were still not going to anticipate that. As a general principle, however, the provision of utilities such as energy and water was a matter that was left to states, or indeed through the states' local government. But as with many subjects, there are several different powers conferred upon the Commonwealth by the Constitution, which can be pulled together to make a kind of tapestry which covers a particular subject. This can be seen from existing Commonwealth laws dealing with nuclear matters. These laws not only indicate the relevant powers that the Commonwealth already relies upon in relation to nuclear matters, but also present another difficulty that the Commonwealth would face with this plan. It is that there are existing laws that prohibit nuclear power generation in Australia. So any future coalition government would have to persuade the Senate, which it's unlikely to control, to remove those prohibitions, as well as to legislate to provide any necessary legal support and protection for a nuclear power industry in Australia. There would be no way of managing this without passing legislation through Parliament. Section 21 of the Commonwealth's Environment Protection and Biodiversity Conservation Act 1999, known as the EPBC Act, prohibits the taking of certain nuclear actions, including establishing a nuclear installation, such as a reactor, and transporting radioactive waste. It relies upon the corporation's power in Section 5120 of the Constitution, the interstate and overseas trade and commerce power in Section 51(1), and the territory's power in Section 122. It also bans the Commonwealth or one of its agencies from establishing a nuclear installation, which is precisely what the Coalition proposes to do. For good measure, Section 140(a) of the same Act says that the Minister shall not approve the construction or operation of a nuclear power plant. It's not clear from this section what head of power it's relying on, but it's likely that it's tied back to those heads of power that are mentioned in Section 21. Section 10 of a different Act, the Australian Radiation Protection and Nuclear Safety Act 1998, provides that nothing in the Act authorises the construction or operation of a nuclear power plant. It also prohibits the CEO of ARPANSA, which is the relevant agency, from issuing a licence for one. It seems to rely in this case upon the external affairs power, as there are several treaties ratified by Australia which deal with nuclear proliferation and the protection of nuclear material and nuclear waste. In addition, the object of that particular Act, as set out in Section 3, is to protect the health and safety of the people and the environment from the harmful effects of radiation. This might also fall within the scope of what is known as the nationhood power, which is a power that's cobbled together from Section 61 of the Constitution, which gives executive power to the Commonwealth, and what's known as the incidental legislative power in Section 5129 of the Constitution. One day I'll do a video about the nationhood power, but let's leave that for the moment. Now, another relevant act is the Nuclear Non-Proliferation Safeguards Act 1987. According to Section 3, the principal object of this Act is to give effect to certain of Australia's treaty obligations. Section 8 makes it clear that it also relies on the corporation's power, the territory's power, the overseas interstate trade and commerce power, as well as the postal, telegraphic, telephonic and other like services power. And it covers matters such as the transport of nuclear material and protection of nuclear facilities. Assuming that a future coalition government could convince the Senate to agree to a law repealing those constraints, what power would it rely on to establish those nuclear power plants? In the past, the Commonwealth has participated in commercial activities such as creating its own shipping line and its own airline. There was a constitutional challenge to the airline, TAA, but the High Court held that it was supported by the interstate trade and commerce power in Section 51(1) of the Constitution. So the Commonwealth can use that power not only to regulate interstate trade and commerce, but to participate in it. The court, however, was so strict about the operation of that power that the airline, TAA, could only fly interstate and could not make a stop within a state unless it needed to as a matter of necessity, like for an emergency. Now, in those days, when the court was deciding this, the corporation's power in Section 51(20) would not have been regarded as sufficient to support the Commonwealth running any business that it wanted, even if it was established as a trading corporation. But the scope of the corporation's power has since been significantly expanded by the High Court, particularly in the Work Choices case. So it's likely now to cover a trading corporation created by the Commonwealth, such as the NBN Co. or indeed the Snowy Hydro Limited, and any laws used then to regulate the operation of such a corporation. Finally, there is the nuclear option, so to speak, which is to compulsorily acquire the relevant site under Section 51(31) of the Constitution so that it's a, quote, place acquired by the Commonwealth for public purposes under Section 52 of the Constitution. Now, this is important because Section 52 gives the Commonwealth Parliament exclusive legislative power to make law, in this case to make laws with respect to that Commonwealth place. But what if a state rejected the idea of having a nuclear reactor within the state? Could it stop it? So far, some state politicians have already rejected the idea. The Victorian Premier, for example, vowed to oppose it. A number of states already have laws that deal with nuclear matters and restrict or prevent nuclear development. Queensland has the Nuclear Facilities Prohibition Act 2007. New South Wales has the Uranium Mining and Nuclear Facilities Prohibitions Act 1986. And Victoria has the Nuclear Activities Prohibition Act 1983. Now, Section 8, for example, of that Victorian Act says that a person shall not construct or operate a nuclear power reactor. Section 4 of that Act states that it binds the Crown in right of the state and, quote, so far as the legislative competence of the Parliament of Victoria extends, in all its other capacities, unquote. Now, what that means is that the law is intended to bind not only the state government, but also the Commonwealth government to prevent it from constructing a nuclear power reactor within the state. So could a state effectively stymie the establishment of a nuclear power reactor by the Commonwealth within the state? And the answer is probably not. First, if it's constructed in a Commonwealth place under Section 52 of the Constitution, the Commonwealth will have exclusive legislative power in relation to that place, and the state laws simply will not apply. Ordinarily, in those cases, the Commonwealth law does pick up and apply state laws to Commonwealth places that are situated within a particular state. Why? Well, otherwise, for example, people could just be murdered in any post office or airport, which is a Commonwealth place, because state criminal laws would not apply. So accordingly, state laws are picked up and applied in those Commonwealth places, as in the ordinary course. But in this case, the Commonwealth would no doubt be sure not to pick up any state law that prohibited nuclear power reactors. Second, outside of that Commonwealth place, the Commonwealth would still need to be able to legislate to deal with things like transporting nuclear waste, energy transmission, power lines, etc. Could state laws effectively strangle such a project by stopping these things? Again, probably not. Section 109 of the Commonwealth Constitution says, when a law of a state is inconsistent with a law of the Commonwealth, the latter, that's the Commonwealth law, shall prevail, and the former, that's the state law, shall to the extent of the inconsistency be invalid. Now, in this case, actually invalid really here means inoperative. The inconsistent law remains a valid law, it just doesn't operate to the extent that it's inconsistent while that inconsistency continues to exist. So, for example, if the Commonwealth law was repealed, taking away the inconsistency, the state law pops back into operation. What this means is that if the Commonwealth Parliament has a head of power to allow it to make valid laws about matters concerning its nuclear power station, and those laws are directly inconsistent with a state law, then the Commonwealth laws will apply and the state law will cease operating to the extent of the inconsistency. If a valid Commonwealth law is intended to cover the whole field concerning the operation of the nuclear power station and the transport and the storage of the nuclear waste and the transmission of energy, etc. from it, then it can also exclude any other state law from that field. For example, the Commonwealth successfully excluded the operation of certain state environmental laws to the building of the third runway at Sydney Airport, and the High Court upheld the validity of the Commonwealth law that did that. While ultimately it will all depend upon the content of the laws that the Commonwealth would need to make, and not being an expert on nuclear power, I don't know exactly what that content would be, it's still pretty likely that the Commonwealth would have enough heads of legislative power to be able to support the necessary laws so that they're valid, and would therefore be able to override any inconsistent state laws as well as any local government laws as well. Putting up a sign that says nuclear-free zone would simply not work. Politics, economics, and practical feasibility are where this issue is likely to be fought out rather than the Constitution. Thank you again for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.